ago, you talked about how the applicant in the examples that you ran through had a number of examiner interviews to try to arrive at a claim form that was acceptable to the examiner. Doesn't having to have multiple examiner interviews highlight that there really isn't a particular specific best practice and that everybody is just trying to figure out how this works? And how much control does a patent applicant have over who their examiner is?
Well, taking the latter point first, a patent applicant doesn't have very much control over who their examiner is. The cases are assigned typically by subject matter, and you end up with whatever examiner handles your particular subject matter. So you don't have much control over who the examiner is. As far as struggling, I think the examples I presented show that there's struggle on both sides. Even in cases where there are multiple interviews, the applicant and the examiner, there was one case I presented where the applicant had come in with various approaches. And even though he came in with various approaches, the applicant and the examiner were unable to reach any conclusion during that interview. And it required multiple office actions before, a little bit of give and take back and forth, before they were able to come to an agreement on language that was satisfactory to the examiner. So, like I said, I think the Patent Office has done what it could in issuing these guidelines. I think they're helpful, but until some of the cases issuing under these guidelines get adjudicated, we don't know for sure whether these guidelines are going to need further tweaking or not, whether they're the answer to the problem.